Good morning. Today we are going to see the second source of law, that is legislation. Okay, legislation means what? Legis means law and lactum, lation means to make. Means legislation is what? Making of law. Okay. Now what Salmond has mentioned or defined, you can say legislation, declaration of legal rules by competent authority, means declaration of legal rules by competent authority. Here competent authority is important, means when parliament makes rules, it is not called as a rule, it is called as a law. Therefore declaration of legal rules by competent authority is called as legislation according to Salmond, while Gray says that legislation means formal utterances of the legislative organ of the society. Means the legislative organ means a parliament, when it declares, when it utters certain things, that declaration is called as legislation. Okay, in civilized societies legislation becomes an exclusive source of law, and in primitive society, in old society, custom was the main source of law. Okay, now legislation can be divided into supreme legislation and subordinate legislation. Supreme legislation means what? The laws which are made by the parliament. Parliament is supreme here. We have given the exclusive powers of making law only to the parliament. Therefore whatever the parliament makes, it is a law. Okay, now supreme legislation is one part, that is a law made by the parliament, and the second is what? Subordinate legislation. Subordinate legislation means delegated legislation, means when the parliament transfers the powers to some other authority, that is a government, and when they make it, that is called as delegated legislation. Subordinate legislation can be divided into delegated legislation, colonial legislation, then judicial legislation, executive legislation, and municipal legislation. We will see one by one. Municipal legislation means when the municipal corporation or a local bodies, when they pass a resolution, it becomes a law, but it is not called as a law, it is called as bylaws, rules and regulations, because they are subordinate to parliament. Okay, similarly when high court makes rules for its own procedural part, then it is also called as rules. Okay, now that is municipal legislation, judicial legislation. Executives pass certain rules, those regulations, those rules are also subordinate legislation. Then colonial legislation. Colonial legislation means when the country is dependent, it is not having independence. At that time, the colonies are not having the powers to make laws by themselves. Then who makes? The dominant country makes the laws for them, and the rules which are made by the colony, they are subordinate to the laws of the parliament. They are parliament. Take example, before independence, India was not having the powers to make laws. It were the rules or the laws which were made in our country, in India, they were subordinate to the laws which are passed by the British Parliament. Okay, therefore that was colonial legislation. And delegated legislation means here Parliament passes a skeleton act. Take Environment Protection Act, it is passed by the Parliament, and section 3 of that act states that the central government can make rules and regulations for the following objectives. Means those are what? Those are delegated legislation. Based upon these powers only, the government has central government has passed many rules, like hazardous waste management rules, then noise pollution rules, biomedical waste rules. So many rules are there. They are all subordinate or delegated legislation. Okay, these are the two types of legislation, either supreme legislation or subordinate legislation. Okay, now legislation and custom, if we discuss together, then legislation grows out of theory, while custom grows out of practice, because it is practiced for a time immemorial. Okay, legislation is the latest development of lawmaking, while customary laws are the oldest. They were at the ancient times, oldest form of law. Legislation is having legal existence, that is de jure existence, while custom is having de facto existence. Okay, legislation is what? Legislation is a relationship, or it expressing relationship between men and the state. While what is custom? Custom is explaining to you how your conduct should be when the relationship is between men and men, that is in the society. Legislation is a result of what? Deliberate practice. It is a deliberate process, positive process done by the parliament. But what is custom? Why customs were created? They were created for public utility, for necessity, isn't it? Therefore, or imitation also. Therefore, customary law is outcome of necessity, utility and imitation, while legislation is a result of deliberate positive process. Legislation that is made by the parliament, this legislative body, it is a specific procedure which will be mentioned in how to make the laws in the constitution. So it is a specific procedure, sophisticated method of development which ultimately abrogates a custom. A law can abrogate a custom, like Dowry Prohibition Act is making dowry giving and taking as an offence, which is a customary practice. Sati Prevention Act, which abrogates the custom of sati, that is also an evil custom which is being abrogated by a law. So many laws are there which are abrogating, which are cancelling the custom. Therefore, it is one of the objective. Means a custom can be cancelled by law. Legislation is a sophisticated method of development which ultimately abrogates custom. Customs have their authority only in the primitive and specified society. In early times, legislation either defined and you can say or supplemented custom in early times, in ancient times. But today what has happened? The complete picture has changed. Legislation is a principal source of modern law, while custom persists where legislation has not yet penetrated. Therefore, I told you where the conduct of human being is not governed by law, today customs govern that conduct. Okay. To repeal a statute, it is necessary to pass another statute. But to repeal a custom is a long and uncertain business. It is always much more convenient to repeal a custom by passing a law. Means to repeal a custom, there is no need to make another custom. We can't wait for that. But like to repeal a law is passed. But to repeal a custom is not passed or custom is not made. We make another, like we make a law which eradicates that custom, which if we feel that against public policy or it is an evil custom, then we pass a law and we abrogate, we try to eradicate the custom. You can't say we abrogate or eradicate. We try to eradicate, because just by passing laws, the evil customs cannot be eradicated. The will of the human being, the society, is very much required. Like Sati Prevention Act was having an objective to eradicate the custom. But why it was eradicated? Not only because of the law, but the society developed itself. The will of the society, the sentiments of the society went against sati as a custom. Therefore, sati was abrogated. But if you say dowry, it is not yet abrogated. Somewhere people give and take dowry. But the objective of the act is there, to eradicate it. One or the other day it will be eradicated when will of the people, all the people will feel that this is a evil practice. Therefore, we have to abrogate it. Therefore, it is a will of the people and the law together can eradicate a custom in a faster manner. Then to make a custom, then time immemorial, we have to wait for that and all. It's a very lengthy practice. Therefore, it is always better to pass a law and eradicate, or you can say try to abrogate a custom. Okay, this is legislation as a source of law. Okay, we have completed here custom and legislation as a source of law. In the next video, we are going to see an important source, that is the precedent, that is judge made laws. Okay, bye bye. See you in the next video.